Thank you everyone for joining. We'll begin in just about a minute. All right, welcome and thank you for joining today's Distinguished Speaker Series event at Bakersfield College, hosted by the Bakersfield College Student Governments Association, BCSGA, and the Office of Student Life in collaboration with the Levin Center. These webinars are made only possible by the BCSGA KBC Student Sticker Services Program, and for more information on that, visit bakersfieldcollege.edu/BCSGA. Just a few housekeeping notes before we begin. This webinar is streamed to various social media sites and will be recorded to be made available up to 2 weeks after the event for students. Closed captioning is available by clicking the closed caption button at the lower part of your screen. This is a webinar event, so you'll not be able to show your video or talk through the mic. All inappropriate questions and comments will be removed immediately. To ask a question, you can do that by using the Q&A button at the bottom of your Zoom toolbar to submit the questions to us. We will review the questions and ask them at the end of the speaker's presentation. The Distinguished Speaker Series brings a community leaders from around the world to Bakersfield whose achievements have had national or international significance. Each speaker was proposed to BCSGA by either a department or faculty member. The events are free and open to the public. This is our final speaker for the school year, so please come back during August to see information on next year's future speakers. Please visit bakersfieldcollege.edu/student-events/DSS. Today's webinar again will be recorded. In case of any technical issues, please stay online as we work through them. In case of disconnection, please join us at Facebook Live at facebook.com/SGABC. Again, if you have any questions to ask during the presentation, please use the Q&A button so we're able to ask your question at the end of the speaker's presentation. You may also post questions on our social media and we'll capture the questions from there. Without further delay, I welcome Reggie Williams, Professor of Philosophy, to introduce today's distinguished speaker.
Thanks so much, Benny. So first and foremost, welcome to Bakersfield College's Distinguished Speaker Series and the 7th Annual Norman Levin Lecture in the Humanities. I'm Reggie Williams, as Benny said, the director of the Levin Center, and I will be doing the additional intros from here forward, quite a few, and then I'll also be moderating the question and answer session. Benny did a beautiful job of mentioning how the Q&A works, so I'll largely leave that as said, but again, I look forward to your questions. We will read them off at the end, as many as time allows. Before we get to Barry Scheck, so tonight's talk is with Barry Scheck, an amazing attorney, amazing for so many reasons. I'm going to mention a few of them in a moment. But before we get to Barry Scheck, the man of the hour, I need to do a few thank yous. I'll try to be concise, but they're important thank yous. So again, I want to thank the Distinguished Speaker Series and the Office of Student Life at Bakersfield College, the entire staff over there. I work very frequently with Nikki, Benny, and Danielle, but all of their support team, thank you to all of them for making tonight work. I would like to thank Nicole from ICM Speakers for helping us bring Barry Scheck to Bakersfield College. I would like to thank Sonia Christian, the president of Bakersfield College, who has entrusted me with the Levin Center now for 3 years. I'm deeply honored and appreciative of her trust in me in the center. I would like to thank Jack Hernandez, one of my very, very dear friends and the former director of the Levin Center. Jack Hernandez ran the center for 10 years, the first 10 years of its existence, and then graciously passed the torch to me, and I will be forever grateful to him for doing so. I would next like to thank Miriam Valenzuela and Susan Penza. Miriam is the administrative assistant who works with me, and of course, ultimately that means she basically runs the place, but my signature seems to be significant. And Susan Penza runs the Levin Institute for Lifelong Learning, and we work together, the three of us, in all sorts of ways, so huge shout out to both of them. I would like to thank BC's Foundation and the events management team, everyone over there. I would like to thank tonight's captionist, LD Lopez, who has done a ton of work for us all year long. So thank you to her for all of that work. And then one more huge thank you before we get to tonight's featured speaker. And that, of course, is a huge thank you for Norm Levin. A couple of comments, because this is the one night of the year where the most of us come together under the name of Levin, if you will. So Norm Levin lived to be 90. He was a practicing dermatologist in Bakersfield for 50 years. He also taught dermatology at USC, and he was an amazing philanthropist. And toward the end of his life, and then additionally, posthumously, he decided that Bakersfield College was worthy of a tremendous endowment, a tremendous gift, the largest gift of a single individual to a community college in the nation at the time. And his gift basically established three things. So single-handedly, Norm Levin donated enough money to Bakersfield College to double our scholarship output each year in terms of money. Secondly, Norm Levin's money established the Levin Institute for Lifelong Learning, which Susan Penza runs, and whose mission is to enable the 55 and older community of Bakersfield to stay active, to stay vital, to stay engaged, and to keep learning. And then finally, Norm Levin donated a considerable amount to establish the Levin Center, which is one of the co-sponsors for tonight. So suffice to say that this event could not happen if it were not for Norm Levin. So huge thank you to Norm Levin. We miss him dearly, but we continue to learn from him and feel his influence throughout the campus and the community. All of that being said, let's turn to the man of the hour, Barry Scheck. So Barry Scheck's CV reads like a book, but of course I will try to be concise. And basically Barry did not object to my earlier introduction to him, pun intended. So I will proceed essentially to repeat it with one minor change. So Barry Scheck is considered one of the 100 most influential attorneys in the United States. He holds his bachelor's degree from Yale. His law degree is from Berkeley. Barry Scheck is professor of law at Cardozo School of Law at Yeshiva University. He is partner of NSB, a law firm, the nation's premier civil rights law firm. Barry Scheck's work is pioneering in the use of scientific evidence in trials, specifically DNA evidence. And Barry Scheck, his work has done an amazing job of serving as a watchdog for crime labs throughout the nation, the idea being that the evidence can only be as good as the processing of the evidence. And so he has helped to ensure that quality control across the country. In 1992, Barry Scheck very famously co-founded the Innocence Project, which to date has helped to get 375 wrongfully accused persons acquitted of their charges, released from prison, their records expunged and restored, etc. He's a published author of the book Actual Innocence. His work has inspired a feature film titled Conviction. He has represented numerous high-profile cases, just to name a few: Hedda Nussbaum, Louise Woodward, Abner Louima, and O.J. Simpson. And finally, he has won numerous awards, but just to name a couple: the Thomas Jefferson Foundation Medal in Law and the Thurgood Marshall Award. It is my tremendous honor and pleasure to introduce Barry Scheck.
Thank you very much, Reggie. And it's a great pleasure for me to be in Bakersfield College and as part of this Levin speaker series. So what I'm going to try to do is to discuss something about innocence, justice, and race. And I do encourage, as I mentioned this morning, any questions about the trial of Derek Chauvin, because I've been intensely interested in it, followed it with great care, and we'll probably mention it as we move on, because it is in so many ways a historical matter. I figured before getting into the larger issues and the larger aspect of the Innocence movement and our Innocence Project and Innocence Network, I just start with a single case. This is Archie Williams. He did 36 years in Angola prison in the state of Louisiana. He just got out, I guess it's about 2.5, maybe even 3 years ago. And this is Archie as we're getting him out of prison in Baton Rouge, Louisiana. He spent 36 years behind bars, and it was a fingerprint hit in a database that cleared him, which I'll explain in a minute. And that's me standing there, but in the middle of the picture in the gray dress is Vanessa Potkin, who is the first lawyer hired at the Innocence Project, which started as a criminal law clinic or clinical program at Cardozo Law School. And to the far left is Emily Maw, who was the executive director of the New Orleans Innocence Project, and in a very good sign of the times. Recently, the chair of the Innocence Project of New Orleans board, Jason Williams, was elected district attorney in Orleans Parish, the city of New Orleans. And he has asked Emily to run what is generically called a conviction integrity unit. That is a unit within the district attorney's office that will review whether people were wrongly convicted. And it's a big new development I'll discuss a bit in this talk. But Emily also calls it a civil rights unit, and also is looking to, part of what we would call conviction integrity is also to do something about people who are excessively sentenced. And so that's all of us walking out of the courthouse in Baton Rouge, Louisiana that day. And here's how the case started. This was one of the very first letters that we really received at the Innocence Project. And as you can see, it was reached us on March 19th, 1995. And Archie wrote, "Dear Mr. Barry, my name is Archie Williams. I'm 35 years old. I'm serving a life sentence for rape and attempted murder of a Baton Rouge woman that I know I didn't, a crime I know I didn't commit. As the years go by, I sit here year after year. It's like no one cares. You have no outside help. People let you down and give up on you after about the first 2 years. Then all you have is prison life. But by the grace of God, I'm still holding on, hoping and praying in faith that someone will answer my letter and help me. I have mailed my case to many places for help, but no response. Talked with everybody I could think of. I know if only one of the persons who picked up my case and read it, they would know I'm not guilty, I'm innocent. If I could get a DNA test, it would prove my innocence. It's all about the rape of a woman, of a big time Baton Rouge attorney. That's why no one wants to take my case in Baton Rouge, because everybody knows the man. I was last denied in the Middle District. I've been here in Louisiana State Prison for 12 years. No one will help me because I don't have any money. I'm trying so hard because I know I'm innocent. I found you by talking to a friend. I know that people must write you all the time, but if you could or would, please find it in your heart to help me. I would appreciate any help that you could give, if it's only you reading my case. In closing is a closing argument of my case. Thanks, and may God bless you and your family, Archie Williams. Now, he enclosed the closing argument in his case. It was very helpful. Archie was actually represented by a public defender who was very good, although horribly short on resources. She later became an excellent judge in the Baton Rouge area and always believed in Archie's innocence. And in that closing argument, what this lawyer pointed to is that the assailant had entered into the home of this poor woman who was sleeping in the morning, attacked her with a knife. There was a struggle, there was blood. She was sexually assaulted, but there was fingerprints on the area by a door where he entered, and some fingerprints in blood. And those were recovered and analyzed. And they excluded Archie Williams. But the question was, who did they belong to? And the closing argument said, find the person whose fingerprints are there, and you will find who really committed the crime. And that eventually happened. I mean, it did take so many years, because the truth is that we first started trying to get DNA testing in Archie's case. We went to the district attorney in Baton Rouge, former National Football League player named Doug Morrill, and literally in a chambers conference, we said, well, you know, please, why don't you just do DNA testing of the rape kit in this case? It could either incriminate Mr. Williams, or it could exclude him, showing he's innocent, and maybe we could find the person who committed the crime. And essentially what Mr. Morrow said to me was, I can't do that because there might be a whole lot of people in Angola prison and here in Louisiana who would be demanding to do the same thing and, try to prove their innocence, which always struck me as a very unfortunate comment. But indeed, there was no statutory right at that time in the state of Louisiana to get a DNA test to prove your innocence. Really, by that time, there were only a few states that did it. When we started the Innocence Project, it was only New York and Illinois. And what we had to do over time was pass statutes in states all across the country. Now all 50 states have some kind of statute that will permit you to go to court, do a DNA test, and prove you're innocent. So when we started this, you really couldn't even get into court to get these kinds of tests. So we had to pass a statute to do the DNA testing for Archie. And as it turned out, when we finally did get it, took maybe 15 years, then it turned out that the semen in the rape kit came from the husband, right? Plainly not the assailant. But that still left the issue of the fingerprints. And we never gave up on the fingerprints. And I'll explain exactly how we solve that. There's a later in this talk. But basically, long story short, we put the fingerprint into a database system called AFIS, the Automatic Fingerprint Identification System, and we got a hit to an individual who had committed, and when you really look at it, there's the home of the victim in this case, and then all around it, 6 other homes where women had been attacked one after another, the same modus vivendi, modus operandi, as it's called. And there was no question this individual committed the crime. We had his prints. He had done others at the same time, all in that area, but he was already deceased. But that was indeed how Archie finally got out. That's a very long story short. So now to step back for a second and look at the overall mission. An injustice anywhere is a threat to justice everywhere. So our mission is to free wrongfully convicted people, reform the system responsible for their unjust imprisonment, and to confront racial injustice anywhere in the world. And we look at this, the right, as an international human right. Every legal system, adversary or inquisitional, should recognize a post-conviction right to prove actual innocence and have a viable process in place to provide relief. And when I say adversary or inquisitional, I don't mean inquisition in a pejorative way. There are systems where the primary investigator is a judge, and that's what they usually mean by inquisitional systems. And in many countries in Europe, that is the system that's in place. We in the United States, the United Kingdom, are famous for an adversary system, but it is different in other places. Either way, it has often been hard to get a post-conviction investigation as to whether somebody didn't even do it. Arguably, they're even more stubborn about it in an inquisitional system because, people become invested in believing this must be true. We convicted somebody, they must be guilty. And what we've been able to prove with the help, certainly of DNA testing, although we do a lot of cases these days without DNA testing, but there were far more innocent people that were convicted than anybody ever believed. And if not for DNA testing, we would have never known. And you might want to look at this as a civil rights movement. We, like my partner, Peter Neufeld, who co-founded the Innocence Project with me and practices in our civil rights forum, Neufeld, Scheck, and Bruston together. That's the way we look at it, as a civil rights movement. And the purpose is we protect the innocent, from getting convicted in the first place with reforms we pass in legislatures. And we try to enhance the capability of law enforcement to find and convict the guilty parties with scientifically reliable evidence. And the good science has always been the hallmark of the Innocence Project and the Innocence Movement, because we did start by relying on DNA. Now, in 2009, the National Academy of Science, our leading scientific institution in the country, maybe the world, issued a report called Strengthening Forensic Science. And this NAS panel, it was a landmark report, came to the conclusion that the only scientifically validated forensic assay methodology test was DNA testing. That so many of the others had not been adequately validated for technical merit scientifically, whether it was fingerprints or which we know can be done right and does have a real probative value, or something like bite marks, which doesn't and will never be validated in our judgment. The NAS covered all of that. You can go to the National Academy of Science and you can download this for nothing, but it's still a seminal report. After 2009, the Obama administration actually responded by setting up a National Commission on Forensic Science to deal with it, and something called the Organization of Scientific Area Committees out of NIST, the National Institute of Technology, to break down all these forensic methods and try to put them in a more scientific footing. I wish I could tell you that it has been an unqualified success. It is not. The NAS report had recommended that there be a separate entity in government that was independent, just devoted to forensic science. They were right. But when the Obama administration put this together, they had a combination of NIST and the Department of Justice. And the key to understand here is that science has to be independent. Laboratories that do forensic testing, 90% of them in this country are embedded in police departments. That should not be the case. They should be independent public entities that are transparent, because they should be an independent third force in the criminal justice system. Reliable scientific evidence, is something that the prosecution should want, something the defense should want, the judiciary, all people that come before the courts. So we've always insisted upon good science. And then the other thing about our movement is it does triangulate the adversarial paradigm, right? We're interested in innocence. We're interested in making sure that whatever brought about a wrongful conviction is corrected in order to make sure it doesn't happen again. And we are not ideological in that way. It is totally focused on public safety. It is explicitly truth-seeking and spiritual. And here, not necessarily talking about religion, but I'm talking about some transformational idea of justice, because that is actually, turns out, a very important part of our movement. Everybody that gets out of prison who's wrongfully convicted, everybody notes, oh my God, these people, if I were them, I would be so infuriated. I wouldn't even be able to talk. I'd be apoplectic, totally angry. And don't make any mistakes about it. These poor people have suffered tremendously. But the fact of the matter is they wouldn't have survived unless at some point they had a moment where they began to forgive and they began to transcend the anger, because if you let the anger fester, it'll destroy you. So all of our clients are extraordinary, and they are the best spokespeople for this movement. And they've been, the keys to passing legislation and winning the hearts and minds of the public across the world. And of course, the remedies, the reforms, it's all a win-win proposition. In the United States, the term actual innocence, believe it or not, has not yet been formally recognized by the United States Supreme Court as a constitutional right. However, I do believe that there's always been 6 votes to that effect. And ultimately, they will get there in explicitly saying it. I think in some ways they may have already in the Trayvon Martin, the Davis case in Georgia. The Supreme Court remanded what's known as an original writ of habeas corpus. If there's any lawyers in the audience, you'll know what I'm talking about. And when they remanded that case, they made it pretty clear that if it ever did come before the court and you had adequate proof, actual innocence would be recognized as a federal constitutional right. But what's happened in the interim is the American Bar Association has posited ethical rules that in some ways already make it clear. The rule 3.8G says that at post-conviction, if a prosecutor comes across material evidence of innocence, they must disclose it to the lawyers, the last known lawyer of the person that was wrongfully convicted. And 3.8H says that if you find clear and convincing evidence of innocence, then you as the prosecutor must do something to vacate that conviction. So these post-trial obligations are extremely important, and they have really led to something new that's developed that I've written a lot about, what we call conviction integrity units. That is to say that prosecutors set up units in their office where innocence organizations and defense lawyers can go with cases where they say, hey, we think there's some reason to believe that this person is innocent, or the trial might have been unfair and a violation of due process. And we believe that these conviction integrity units are best run by, frankly, either defense lawyers or innocence lawyers, people who've had that experience, and not to say that prosecutors can't do it, or that somebody that's had a history of prosecution can't do it. But so far, the people that have been able to do this the best are former defense lawyers or innocence lawyers. And I think that's because so much of what makes getting to correct outcomes in our system has to do with cognitive bias. And sometimes when you've been socialized in a particular prosecutor, any prosecutor's office or any defense office, you do see facts and things differently. So we try to design these conviction integrity units where, again, people can engage in a non-adversarial search for the truth and share information back and forth and get past all the procedural problems, procedural bars that can sometimes completely stymie post-conviction litigation. So 1989 was the first post-conviction DNA exoneration in the United States. It was just coming into the courts. By 1992, we had formed the Innocence Project as a clinical program at Cardozo Law School. By 2000, at a number of other law schools, we began to develop a network of innocence organizations, again, mostly in law schools, some in those days involving journalists. In the state of California, you have three great innocence organizations. One of the first ones, our friend Justin Brooks at Cal Western Law School started the California Innocence Project. As he likes to say, he was one of the original gangsters, I'm quoting Justin. And then, there's the what's known as the Loyola Innocence Project, maybe changing the name to Los Angeles Innocence Project out of Loyola Law School. And then we have the Northern California Innocence Project. But they're all across the country. And now we have 56 innocence organizations in the United States and 13 international organizations. And again, we're talking California here. I'm in California virtually. I still have my bar card. Justin at Cal Western Law School, for example, has been a great proponent of the international efforts. Is a fluent Spanish speaker, and he has organized an organization that really does cover Mexico, Central America, Latin America called Red Inocente that looks at these issues in Latin America. As Reggie indicated, so far there have been 375 post-conviction DNA exonerations since 1989. And what's really important, and we talk about the DNA exoneration separately and have from the beginning, just because everybody knows that this is the magic bullet. And if you were exonerated by DNA, most people do not question it. More to the point, because of this CODIS DNA data bank, in 47% of these cases, the person who really committed the crime has been identified. So it's very hard for people to argue with that. But if you go look at the Registry of Exonerations, which is an extraordinarily important organization, it's now housed at the University of California at Irvine. Our friend Simon Cole, who, by the way, is a fingerprint expert, he's a historian of the development of fingerprints and does a lot more than just that. But it also is combined with the University of Michigan, which really started it, with our friend Sam Gross, a professor there, and Michigan State University, all combine to put out the registry. And what the registry does, just go to the National Registry of on Wrongful Convictions online, and you will see a count every day of all the wrongful convictions, which is both DNA and non-DNA. And right now, I looked this morning, 2,774 DNA and non-DNA exonerations. And exonerations are defined by the registry as being cases where somebody is convicted, then their convictions are vacated based on new evidence of innocence, then on remand to the courts, the prosecution either dismisses the case, the defendant goes to trial and is acquitted, or a governor pardons them. So that's how an exoneration is defined. Is it possible that some of these people who meet that definition might still be guilty, and you can't say that they're quote unquote actually innocent? Yeah, that may very well happen. That is possible, but when you look at the cases, the overwhelming likelihood is the vast majority of these 2,774 people are innocent. And we keep, of course, the 375 DNA exonerations separately as a number because nobody's arguing with those. They're bulletproof, to be honest. And when you add up all the wrongful convictions since 1989, that's when the registry starts counting. It's more than 2,840 years lost. Is just one way of looking at that horrible pain and suffering that so many people went through, because it's not even just the exoneree, as we call our clients, but it's also the families. You put an innocent person in jail, and it's like putting really the whole family there, generations. So let's look at the factors. Eyewitness misidentification has long been known as a major factor in wrongful convictions. There's our friend Cornelius Dupree in Texas, but the number has been reduced over time. This number may be inflated just in terms of the DNA exonerations, but eyewitness misidentification is, of course, a serious cause of wrongful convictions. And we've done a lot of legislative work based on great science to minimize the number of misidentifications by changing the procedures by which identifications are made. And I'm very happy to say that 2 years ago, the California legislature finally passed a bill that is a very good one, instituting a lot of these reforms. It's not solved by any means, because even if you do it right, a third of the time, eyewitnesses will pick a filler in a photo array or a corporeal lineup. And a filler means somebody that you know didn't do it. So it is still cognitively a very problematic exercise to try to make an identification after a crime where people may have limited opportunity to observe, and our memories are not quite what you think they are. Unvalidated forensic science. I've talked about the National Academy of Science report, involved a factor in 50% of the cases, false confessions or admissions in 25% of the cases, incentivized informants in 20% of the cases. This is a terrible problem that really is so unnecessary. You may know it from Orange County, California recently had a huge scandal on informants. In our book, Actual Innocence, we talk about Los Angeles County and the famous informant Leslie White, who was everywhere, jailhouse informant. But here's a case that involved it. This is Betty Ann Waters on the left and her brother Kenny Waters. And Kenny was convicted in a small town, Ayer, Massachusetts. His sister, who hadn't finished high school, she didn't have a GED, she didn't have a diploma yet, watched the trial, knew her brother was innocent, and he tried to kill himself. And said to her, she said, "Kenny, you can't do that." I'm really paraphrasing here, but he said, "Listen, I promise I won't kill myself if you become a lawyer, because you're the only person I know that can get me out of jail." And this is a true story. She indeed, had her GED, went to college, graduated law school with very minor assistance from the Innocence Project. She was able to find the DNA evidence, and Kenny was exonerated. By the way, there was also fingerprints that we're still trying to put into the APHIS database that had exonerated him, that were not disclosed by the prosecution, a major problem. But eventually, a movie was made about this case called Conviction. It stars Hilary Swank as Betty Ann Waters. She's got, 2 Oscars. Sam Rockwell playing Kenny. He's now has an Oscar. Melissa Leo plays this female police officer who had a lot to do with why Kenny was wrongfully convicted. She's got an Oscar. And a really great person, Tony Goldwyn, who is an amazingly talented actor and director. But you may remember him as the President of the United States from Sandra Rhimes' Scandal, right? But he directed the movie. And so we're very proud of it. And I think it stands the test of time. Go check it out on Netflix, and you'll kind of see the whole operation in action. And just remember this: we did not change one name. Everybody's name in this story is there, so that's a way of telling you that it is certainly based on a true story. And by the way, there's another terrific movie, Brian Banks, about the this individual, Brian Banks, a wonderful guy, exonerated by the California Innocence Project, and they'll be the first to tell you in part himself, who was wrongly convicted in high school, essentially, of a sexual assault, which blocked him from being able to go to the University of Southern California under Pete Carroll, who probably would have selected him. And he never got to play in the NFL, but eventually he was exonerated. And there's a wonderful movie about that that was out, I think, 3 years ago, Brian Banks. And you should check that out. Inadequate representation, 20% of wrongful convictions, but that we don't really have a good measure of that because the standard for what constitutes ineffective assistance of counsel, unfortunately, in this country, is we like to say, if you put a mirror under the nose of the defense lawyer and it fogs up, then the courts may well say that was adequate counsel. It's a major problem, and we don't have a good way of tracking it. The true number in terms of it being a factor is probably 2 times that. Prosecutorial misconduct, extremely serious issue. This is Michael Morton in Texas, did 25 years. for killing his wife, which he didn't do. It's an amazing case. If you go online, you'll find a very good documentary about it. Michael has written a wonderful book himself. But what's really important about this case is that we literally found that the prosecutor who tried him, who then went on to become a judge in Williamson County, Texas, and an author of books about how to be a good prosecutor, that this prosecutor and then Judge Ken Anderson hid this exculpatory evidence. And in the end, DNA did exonerate Michael. We found the person who really committed the crime, but we also found the hidden exculpatory evidence. And in a very arcane system they have in Texas, you can literally file what's known for a court of inquiry, which is like a citizen's grand jury. And we brought a court of inquiry against the then Judge Ken Anderson. He was convicted of criminal contempt for not turning over the DNA, the exculpatory evidence. To our knowledge, the first time in the United States that a prosecutor had been convicted of criminal activity for hiding the exculpatory evidence, which is astonishing when you think about it. But he only did, it was a misdemeanor. He did 8 days in jail. Michael did 25 years. But that case changed everything in the state of Texas. Michael went on to work with our policy department and others at the Innocence Project. They passed what's known as the Morton Act in Texas, which created the best open file discovery system. It's all digital in the United States. It's a model for everywhere. You should follow all of the provisions of that in California. It would help. Changed a lot of the rules with respect to bringing bar complaints against prosecutors who do, in fact, commit acts of misconduct. Michael has even been able, in New York, when we did discovery reform, we ran commercials with Michael Morton talking. He was, you might have seen him, 60 Minutes did his story, and they aired it 4 times. That's how affecting he was as a witness to innocence. And then, of course, race. It's almost absurd now where we're at in the wake of George Floyd's murder and all the different things going on in this country. Of course, race is the original sin. Race is the factor that pervades the criminal justice system. It is no longer really a debatable point that we have systemic racism within our criminal legal system, and that is what we are trying to deal with and cope with now. So what else can there's much that can be said, but I would be talking for the rest of the evening. Okay, so I mentioned the CODIS system that has been used. That's the DNA data bank to find people who really committed the crimes. But there's also the APHIS system. That is the fingerprint system that actually was able to clear Archie Williams. So I don't know if, maybe Reggie and Benny, you can tell me. We go back to look at Archie Williams for a second again. Do any of you recognize Archie? Because Archie, after he got out of jail in Baton Rouge, Louisiana, the first thing he said to the cameras, they said, "What do you want to do next, Archie?" He said, "I want to go on the Steve Harvey show." So we were able to get him on the Steve Harvey show, and Steve Harvey was very generous. And then after that, Archie was known in Angola, the prison in Louisiana, where everybody's doing life or is on death row, unfortunately. He was a great singer. He led the choir. And so he was able to get on the show, America's Got Talent, which we're very grateful to Simon Cowell, who contributed some money after seeing Archie's performance to the Innocence Project. Archie went on to be a finalist in America's Got Talent. So I'm just curious, looking at Archie now, how many people, if you could hit your raising your hand button, because we're not together, how many have seen Archie on America's Got Talent? There are millions of people that follow it on Facebook and Twitter. Reggie, did you have a count there? Was it a lot?
It's considered, I mean, so far I'd say 15 to 20 of the 145 people in the crowd.
Well, we'll see how quickly it ends, Archie's fame. I encourage you to go online and look for Archie Williams singing on America's Got Talent. His first, he did a Elton John song in a really interesting and different interpretation, and he blew everybody away. So you may want to take a look at that. But, you know, it took us, I don't know, 25, 30 years to get this APHIS search for Archie. And APHIS is getting much better. They do palm prints now. They didn't for a long time. But only 6 states authorize APHIS searches. And there is an Assemblyman Lackey from the, I think it's the 36th Assembly District, has introduced a bill, Assembly Bill 760. And he'd be the first to tell you, I think, that he is a conservative Republican, but he put in this bill to create APHIS access in the state of California. Write your local representatives and let's make sure that bill passes. Now I'd like to talk to you a little bit about, in terms of what we can do about the issues of race and systemic racism and problems in policing in the criminal justice system in the United States. I'd like to talk for a few minutes about certain aspects of the George Floyd Act. And this is the bill that is passed out of the House of Representatives. It was introduced in the Senate by Cory Booker and now Vice President Harris, and it has a number of different provisions to it. One of them that I'll talk about a lot now is what they call a police misconduct database. That is to have a national database that we can study and try to analyze about police officers who have been found by their own police entities to have committed acts of misconduct. And the second provision that they talk about in the George Floyd Act is a police decertification database system. And that is just about every state in this country have what they call police officer standards and training. And the idea is that every police officer, like any professional, ought to be given a license. Now, this may stun you because if you're really trying to keep track of law enforcement misconduct, it may surprise you to know that police in the United States do not have unique identifiers. The shield number you see does not necessarily identify uniquely that officer. They get reused, handed down. But if you had a licensing system, as we have for lawyers and doctors and accountants and all kinds of professionals, you would be able to, number one, keep track of people. You can't manage what you can't measure. And you would also then have a system in place to decide whether or not somebody should lose their license. And so right now in California, you have pending, last session it was Senate Bill 731, this one is Senate Bill 2, a new system in the state of California for licensing and then reviewing the conduct of police officers all across the state. It should be the same standard for everybody in terms of deciding whether or not somebody ought to have their license suspended or taken away. And you've got to keep track of it. And then the question is, well, who decides that? You have a standard in place. It shouldn't just be as it is in many places. Well, we don't decertify you unless you're convicted of a felony. I mean, you can do things, you can be caught being dishonest or doing acts that are not even felonies, but should disqualify you from being a police officer. But how does it get decided? And what is really good about Senate Bill 2 is that it creates a system statewide, same standard, but statewide oversight mechanism that consists of impacted people from the community. It consists of civilians like prosecutors, defense lawyers, academics who study policing, as well as police officers from middle ranks and senior supervisory ranks. All of those people will sit on the Oversight Commission under Senate Bill 2 and make a decision about people keeping their licenses and adjudicating it. If you don't like the decision, you can appeal and you can go to an administrative law judge. Nobody is saying for a second that police officers shouldn't get good defenses or get due process. But the system is not going to work if you just have, as presently happens, pretty much just police officials reviewing their own. We're not, lawyer systems have the same problem, and a lot of discipline boards try to include civilians on them, non-lawyers, I should say. But this is very important to do. And you get really, almost a case law. And I would be less than candid if I didn't tell you that, one of the big problems is, police unions and the way they've had a stranglehold over the disciplinary systems in the state of California and across the country, as we'll talk about in a minute. But this is a good, fair, democratic, and sensible way to go about doing it. But the key thing in terms of these two provisions of the George Floyd Act is that it's wonderful to say we'll have a national police misconduct database. We'll have a national decertification database so we can track if a police officer is fired in one state or one jurisdiction and they go to the next one, we'll know because we'll be able to look at their license and their histories. So we won't have what is sometimes called the wandering officer. It's a great law review article by Rappaport, and I forget his co-author out of the University of Chicago, that tracks the wandering officer in Florida. And as for a second, I'll tell you why Florida is so important in that regard. And then it also has reforms in there for police practices, the George Floyd Act. And you know about a lot of them, no-knock warrants, Breonna Taylor, chokeholds, Eric Garner in Staten Island, and then training on de-escalation. There's a great organization called Noble that works with police officers so that, for lack of a better term, the good officers will learn how to calm down and de-escalate officers that are doing bad things. And that's an important kind of reform. Oddly enough, in Minnesota and Minneapolis, I think there was some Noble type training for the officers, and Derek Chauvin were involved in that case. So it's one thing to get training. It's another thing to implement it. In the policing world, they always say culture eats policy for lunch. It's not an easy issue. And then, of course, there's a reform on what's known as qualified immunity. And a number of states have taken action on this. Colorado, just the other day, I believe New Mexico, Massachusetts did something about it. But qualified immunity simply means under the law that if you're a police officer and you definitely violate somebody's constitutional rights in your actions, you're not, the entity you work for or you as an individual are not necessarily going to be liable because they say, even though you did violate the Constitution, did you do it in good faith because you didn't know what the rules were? And that really shouldn't be an excuse. If you violate the Constitution, you use excessive force, that you should be able to get a decision on the merits if there really was a violation. But that effort to get rid of qualified immunity, which, by the way, is supported by lots of conservatives, the Cato Institute, lots of conservative groups are very much against qualified immunity. And we even thought some conservative justices in the Supreme Court were going to take action. But this will be the most controversial part of the George Floyd Act, and as Congress begins to approach it in the next few months. But I want to talk about the police misconduct database and the post-decertification statutes, as I talked about briefly, Senate Bill 2. And let me tell you why, give you a little history here. This was a chart of just a few years ago where it showed which states kept secret the acts of misconduct by a police officer. And here I'm talking about instances where the police department itself makes a finding that a police officer did not tell the truth or used excessive force or committed some kind of sexual misconduct within the department. And they make a finding against the individual, but that does not become public. And in fact, the way it worked, California, they called it the Pitchess Rule. In New York, we called it Civil Rights Rule 50A, because New York and California had the two worst rules in this regard, the two most secret processes. And yet, a state like Florida, for example, has a great tradition of sunshine laws. In Florida, there are depositions in criminal cases that stuns people. You make a public record or Freedom of Information Act request in the state of Florida, a police officer's rights to keep records confidential, personnel records confidential, are no greater than teachers or any other kind of public employee. And that's one reason why in Florida, they have a very robust system of what they call police officer decertification, what I was talking about before, whereas that doesn't really go on in any considerable or appreciable way in either New York or California. So what happened is that after, here's the Pitchess Law in California, as it's called. Here's my photo showing you on the one hand, Pitchess in California, Penal Law 832, Subdivision 7. In New York, it was Rule 50A. And it began to, a movement has been created to try to roll back this kind of police secrecy. And ultimately, a vision that a lot of us have is that there should be databases in each state and each locality. There should be three kinds of databases involving law enforcement misconduct information. First, there should be a public database where these adjudicated acts of misconduct, and even ones where they were found unsubstantiated but not unfounded, they should be known by the public, and it should be a public website that you can go to see it. And this is something, when it's on a public website, the DA would know about it, the defense would know about it, judges would know about it, and they would know about it at the beginning of the case, not at the end of the case. Because the way that these systems worked in New York and California is the only time that you might ever see any police misconduct information under Pitchess in California, under 50A in New York, is on the eve of trial. And only 3% of cases go to trial. And even on the eve of trial, you only get to see a little bit of this information because they have to meet other evidentiary requirements. So the truth is, the full extent of adjudicated acts of prosecutorial misconduct and allegations, serious allegations, were simply not known. So what we're calling for is there should be a public database to do this. And in a second, I'll show you one. Then there should be a defender database where the defense lawyers should themselves be able to track it and keep their own information about officers. And then the prosecutors should have their own database where they can collect, as the defense can do, secret work product, confidential information about officers so they know who they're dealing with and they keep track of behavior. If they believe, for example, a prosecutor believes that an officer has lied to him or her, that makes a difference. So that's what we'd like to see in each jurisdiction. That's the vision. And we also want to see these post-decertification statutes, all across the country. And again, I just tell you, I'd like to see Senate Bill 2, the California version, pass this session and in every state across the country. But here's what's happened. Here's what the typical kind of public defender office or would look like, or even prosecutors' offices across the country, all this paper, right? And what would happen is people just, you needed to have certain kind of people with institutional memory to see what was going on. So take the city of Philadelphia. On the left, my left as I'm facing the screen, is Brad Bridge, who was a longtime public defender in Philadelphia. He's still there, great guy. And brilliant. He was Harvard. If this is a measure of whether people are smart or not, Brad is a guy that went to Harvard undergraduate, Harvard Law School, went to the Philadelphia Public Defender Office, never left. And to the right, you see Meek Mill, the famous rapper, and very talented man, by the way, and thoughtful about these issues because he went through a lot of struggles on a probation violation, and the underlying case, it turned out, against him involved some police officers that had been engaged in acts of misconduct. And basically what Brad Bridge was able to do over the years that none of us really paid much attention to, except for him, is that he would watch very carefully and he would say, oh my God, here's some Philadelphia police officers who have been convicted by federal authorities because they got involved in narcotics dealing. They themselves were criminals. And Brad said, well, let's go back and look at their past cases. So we know of September 1st, 1995, these 5 officers, we now know because of the federal conviction, were engaged in dealing drugs and lying all the time to their superiors and everybody else. They're acting as criminals. Well, every case they did from September 1st, 1990, I'm making that date up, for the next 10 years before they were caught, we have to look at those cases. And if those cases depended exclusively on those officers and there's no other independent evidence to support those convictions, the conviction should be vacated and the prosecution, if you can retry them, retry them. On 2 different instances over the years, Brad was able to get more than 100 cases vacated just because he was keeping track of which of the officers had committed the worst acts of misconduct. And we all began to realize what he was doing was very important, but he was all Brad Bridge thinking about it and keeping track of it. Here now is Josh Teffer from University of Chicago Exoneration Initiative, and his client is standing next to him. And just to the right of the client, the guy with the beard and bald, there's somebody sticking out an arm right in front of him, is Mark Rattart, who was the head of the Conviction Integrity Unit in the Kim Fox, the new progressive prosecutor in Chicago. And in Chicago, there was a Detective Watt, and Detective Watt was a criminal. And he was dealing drugs and framing people in the community so he could keep on dealing the drugs. And every case that Watt and his crew were involved in were then reviewed. And I think they're up to more than 73 cases being vacated. This is Brooklyn. That is Officer Scarcella. And Officer Scarcella was caught, lying in a case. And to the right is Derek Hamilton, incredible guy with his daughter, a jailhouse lawyer, superb, pretty much got himself out of jail, but he was involved in a Scarcella case. So what happened is the late Ken Thompson and then his successor, the now district attorney in Brooklyn, Eric Gonzalez, started their what they call a conviction review unit. And what they began doing is looking at all the old Scarcella cases. And within the first 2 years of Ken Thompson's reign as DA in Brooklyn, there were 27 exonerations looking at these cases. And most of them did not involve DNA testing. And these were murder cases. So we know that if you go back and you look at these old acts of misconduct, all kinds of things happen. That's my friend Cheryl Pilot, who's a death penalty lawyer and a civil rights lawyer in Kansas City. And we worked together in the case of Ron Williamson and Dennis Rich. She worked on the civil case with me, which John Grisham wrote a book about called The Innocent Man, His Only Non-Fiction Book, and it became a Netflix series that you probably can still see online. But Cheryl has been involved, and I am working on the civil rights case with her, full disclosure, but on the case of Lamont McIntyre, who you see in the right with his mother, Rosie McIntyre. And to the left is Detective Golubsky, Roger Golubsky. And this is a man who we have alleged in our civil rights case exploited particular sex workers in Kansas City, Kansas, particularly African-American sex workers, for sexual favors, even in the police station. And he would also use them as informants and get information that he could then use with the trade back and forth with drug dealers. And Golubsky was in with drug dealers and with exploiting all these women. It's pretty awful. In fact, a very long story short, he wound up framing Lamont McIntyre for a murder of two individuals who had robbed a crack house in Kansas City, Kansas. It's believed that we know who actually committed the assassination of those two people, who was an individual that was connected to the drug dealers. And Golubsky managed to frame Lamont McIntyre by pressuring witnesses and other measures. And I'm not just saying this lightly because there was Lamont's conviction was vacated, and then they passed a law in Kansas called the Lamont McIntyre Bill that had to do with finally getting compensation to people that were wrongfully convicted, and then Lamont was able to recover under that statute. So nobody is quibbling about whether or not Lamont is an innocent man wrongly convicted and frankly framed by Roger Golubsky. If you go online and start reading about this case, it'll blow your mind. But that again, how many Golubsky cases and cases of people that he was working with are wrongful convictions? I'm sure so many. And the issue is just getting the resources and being able to systematically go back and audit those cases. Here's one of our more recent exonerations, 2019, January. Hugh Burton, coerced into giving a false confession in 1989 by detectives from the 47th precinct in the Bronx. The detectives who just 2 months earlier, and Hugh was a teenager, he was 16 when this happened, also had been coerced into giving false confessions by these same police officers who also, we have alleged, fabricated evidence in order to cover up what they did. The Bronx Conviction Integrity Unit worked with us in exonerating Hugh and also is doing an audit of other cases involving these same detectives. They're looking at 31 of them now, they say. So you can see how policing runs in patterns, and we have to look at networks and try to figure out how it goes bad. And that's one reason it's important to track this information. Now, about 5 years ago, I ran into a woman named Cynthia Conti Cook, who was an attorney at the Legal Aid Society, their special litigation unit, and Julie Ciccolini, who is a technologist working in this office, and they did something which I think is really quite brilliant. They invented an application that would track police misconduct data, because this was before the repeal of 50A in New York, and we knew nothing really about the police officers. So what they did is they began, because they knew something about data, they began collecting all the cases where district attorney's offices sent Brady letters. That means letters to the defense about exculpatory evidence. They tracked their overtime, which is actually a public record, and a real good tip is to follow the officers that were piling up a lot of overtime. That's a public record. To the extent that internal affairs records were made public, they tracked that. They went to PACER, which is the system that keeps track of all federal filings, and they looked at all federal civil rights cases against police officers. They also tracked all state decisions where courts might have found that officers were not credible or violated the Fourth Amendment. They looked at these criminal court decisions. To the very small extent you could find anything about officers from public disciplinary proceedings in New York, which was very little. And then they would scrape the names of these officers every time they appeared in a newspaper story. And all that is public information. And they would put all of that information into a cell phone, right? They would gather it into a database, and every time a legal aid lawyer walked into court and they found out who their client was, they could go to this phone, cloud-based, desktop, et cetera, and they could look at all the information. One of the other things that they did as well is that they would get social media postings of the cop, which technically is public information, but we wouldn't recommend putting that in any kind of a public database. But the defenders would get this information, and by the way, the prosecutors track that as well, because very often, police officers sometimes say things in social media. You've seen this in all press reports that indicate that maybe they're not fit to be officers. So they would go into court with this phone, and I saw this and I just couldn't believe it. It was a work of genius. And it's built to handle any kind of misconduct, et cetera. So from this database, the application for the defense lawyers, that they will follow people, they will follow groups, they will follow the substance and the content of law schools, and the incidents. And all of this, here's some social media posts that are pretty crazy. I won't go into them right now. And the Legal Aid Society, which is just one public defender office, they created essentially what we would call a federated system of databases. They would share a lot of the information except for what they were prohibited to by protective orders. They'd share it with the Bronx defenders, the New York County defenders, the Brooklyn defenders, the Queens defenders, as legal aid is in all 5 boroughs. And that was really an extraordinary effort. Now that they've repealed 50A, that is amazing. And what happened just from the creation of this defender database is that the impact is amazing. You get this information at the beginning of the case. It affects the bail decision. It affects the charging decision. It exposes test-a-line. And just think of it. You really have to have some perspective. Not only would what goes into the database, if you have a case with a police officer and there is a body cam video or there's a surveillance footage that shows that the officer did not tell the truth or committed an act of misconduct, every time that officer testifies, that tape should be used to impeach the officer's credibility if you catch them. And that is what's going on across the country. And, you may think that all of a sudden there's all these examples of police misconduct against people of color in this country. But I'm old enough to tell you that when I was growing up in the city of New York, there were constant cries about police misconduct, but there were no videotapes. And we're just living in an age where there's a lot of surveillance cameras, body cams, people with phones that are filming things, and that has just opened it all up. So you can expose people that are testifying, and you share transcripts. It guides investigations, and it ultimately improves outcome. So I like to think of this, and I've written about this, that this kind of defender database can create a virtuous cycle. The defender database, you use it in court, it forces the DAs to create their own database and go seek the information and use the data in the media. And then this pressure, the police department will be pressured by the defense and the press and the public and the prosecutors to change and disclose. And that's what happened in New York. District Attorney Cy Vance, he was saying, wait a second, I want to know about all this misconduct data at the beginning of the case. Give it to me. And the New York City Police Department, and he spoke for all the district attorneys in the city. And they said, no, we're not going to give it to you. You only can see it at the end of the case. That's what 50A says. That isn't even what 50A said. So this all led to a big movement to repeal 50A. And finally, after George Floyd was murdered, boom, it happened. Here's a very important thing. You can go online. You may have never heard of it, but there's this wonderful press institution called the Invisible Institute. And if it has something called the Citizens Police Data Project, CPDP. And if you go online and you see it, it was started by our friend Jamie Calvin, who's a great journalist. He is the person that he won a case with his friend Craig Futterman at the University of Chicago Law School called Calvin versus the City of Chicago. And years ago, they got 26 years of police misconduct data, which included both adjudicated acts and allegations that were found unsubstantiated as opposed to unfounded. All that was disclosed as matters of public record, and they began to collect it on the Invisible Institute, and they set up this database. Not as granular as the legal aid database, but really, really an amazing research tool and a whole series of amazing articles. Here is Jason Van Dyke. He's the officer that shot Laquan McDonald and was convicted for having done it. Jamie was actually the person that was to whom the tape was leaked by people. But when you look at Jason Van Dyke, this guy had 26 allegations against them. More than 95% of the officers on the force, only one was sustained, but the others were just, quote, unsubstantiated. 20 of them were use of force complaints. It's extraordinary. And Jason Van Dyke's not alone. Derek Chauvin, the reason he's not taking the witness stand today is, among them, I'm sure, is that he has all these other adjudicated and acts of misconduct against him, as well as other allegations. Eric Garner, you've heard of him. He was strangled in Staten Island. The officer that did that had undisclosed adjudicated acts of misconduct against him. Tamir Rice, the child shot in Cleveland, same thing with the officers involved there. I could go on and on and on. In virtually all of these cases, we see it. This is why it's so important to find out this information. So if you have a public database, same thing, a virtuous cycle. The defenders get it, you use it in court, the DAs create their own database, the media writes about it, there's pressure to disclose it, and you really begin to get change. And here's a California story, and this I'll close with this. We now have this situation in the state of California where we want to get public databases out there. And so there are 40 newsrooms in the California Reporting Project that has followed up trying to get evidence of adjudicated acts of misconduct against police officers. The ACLU, the press, the public defenders, everybody is going to be contributing to a public database this way. Defenders and the press, they'll protect their own work product information, but they'll file what's known in California as Public Record Act requests to get this information from the hundreds of police entities and put it in a public database. If we commonly code and tag that data, we'll be able to do great research and data mining. It really started with Senate Bill 1421, which was passed in the last session, 2 years ago, I believe. And I'll give you a short history of how it got passed. And this is true in California. The Sheriff's Department had a list of hundreds, I think it was really 300, about 300 deputies with history of adjudicated acts of misconduct. And we're talking about people that put Tabasco sauce in their shirts and said it was blood, that were engaged in sexual misconduct with people on the force and also civilians. Those were some of the most hair-raising kinds of acts of misconduct. But they wanted to take all of this and give it to the prosecutors, the Sheriff's Department did, because they thought the LA prosecutor ought to know about it before they use any of these people in cases, because the Sheriff's Department believed they didn't want to rely upon them because they didn't trust them. That's what they meant on a Brady list. And so when they tried to get, the Sheriff's Department tried to give it to the LA prosecutor, the union intervened and moved to enjoin them. And they took it to the California Supreme Court and the union won. And after the union won, this led State Senator Skinner from Berkeley to get passed Senate Bill 1421, which is, a good start. But we have a new bill in, I think it's 776 this time, that should greatly expand the transparency of 1421, because 1421, really sort of tracking the LA Times story, looked for acts of dishonesty. You file a Public Record Act request about officers, you should be able to get that. It looked for sexual misconduct, you get that. But there's all kinds of other things like excessive force. Those records were not made available under 1421, and there are other problems with it that are blocking access. But all those people that I were talking about, the press, the working together, the defenders, the Civil Liberties Union, Peter Bybring of the ACLU in Southern California has done an incredible job with this, getting the bill passed and outlining it and creating, he's one of the major architects of Senate Bill 2. And ultimately, we want everybody to work together. We're trying to form something. Hopefully, you'll see some public announcements about it soon with Berkeley and Stanford and press, journalism schools and data scientists called the Community Law Enforcement Accountability Network, so that we can really use data science to evaluate all this information and really create effective civilian oversight of police departments and get those decertification bill passed and the database passed. And that is really, you have to go state by state in order to make the George Floyd Act an ultimate reality and effective instrument of change. But that's what really has to be done. So with that, Reggie, I think I will cease. I lost track of the time, but I was faster. Yes, I was faster this morning.
Thanks, Barry. No, awesome job. Incredible work that you do, and a great talk. So let's take a couple of questions. Keeping in mind the time, I don't want to keep you too late. You're on the East Coast and such. I'm going to start with one that came in on my phone, and then I'm going to turn to the Q&A function, and we can just read a couple of them down. And you let me know when you've had enough, because obviously you're 3 hours ahead of us. The one that came in by my phone. How much interest have government agencies shown in either taking up some of the work of the Innocence Project or using tax money to fund the work? Is this something you think should happen, and how much public support is there for it, do you think?
Well, we, the Innocence movement and organizations have gotten federal funding over the years. Now they're funding the conviction integrity units, cooperative entity, from cooperative efforts of innocence organizations, as well as prosecutors' offices working together. There was a wrongful convictions grant program that gave money. $1 million to the federal government is nothing, but to our organizations, $1 million spread out over a number of organizations goes a long way, or a few million. So there's federal funding for that. We did get federal funding for DNA evidence, DNA testing, something called the Justice for All Act. When you help the crime labs do their jobs better and you strengthen a lot of these forensic assays, that helps innocence organizations. On a state level, there's all kinds of funding. We have great cooperation, by the way, from many police agencies and associations. The largest international police organization, the International Associations of Chiefs of Police, IACP, has been a great ally in trying to bring about eyewitness reform and videotaping of interrogations. So there is some government funding, but not nearly enough, frankly. This should be a better funded movement, but most of our innocence organizations go out and we raise money from foundations and from the public. And, you can go online and you can find the innocence organizations in California, the Innocence Project, donate, find some billionaires, and everybody will do better.
I'm going to just basically scroll down at the top. What are your thoughts on qualified immunity for police and potential overhauls to those laws, like Maryland's recent repeal of the Police Bill of Rights?
Yeah, Maryland's, thank you so much, Chris Dyson, for that question. We worked hard to get the repeal of Maryland's, the Police Officer Bill of Rights in Maryland, because, again, just take something very simple. If there are all these crazy rules that prevent police arriving at a crime scene, arriving at a shooting where somebody's been shot, right? Just take that incident that happened today in Chicago. You can't do a crime scene where you're, figuring out where all the shell casings were and the bullets, where everybody was, and you're trying to figure out all the forensic evidence and test things and pick it up, unless you get a statement from the police officer about what happened, right? And years ago, Peter Neufeld, Johnny Cochran, and I sued the New York City Police Department in the case of Abner Louima, who was, you may remember, was a Haitian citizen in New York City who was taken into a police station in Brooklyn, and an officer, Detective Volpe, Officer Volpe, impaled him into his rectum with a mop handle. And lots of other officers there saw it, and it's a miracle Abner lived. This became such a big incident in the city of New York that we had George Floyd type demonstrations for months. And eventually the government prosecuted the officers successfully. But what happened is that all the officers engaged in that case got together and they all got with their police union representatives, Policemen Benevolent Association representatives, and they made up a cover story. And that's what happens in so many of these cases. They made up a cover story before anybody ever interviewed them. Eventually, the way the prosecution was made is that certain people broke ranks and testified against their own, which, they call it the blue wall of silence, and that rarely happens. So we filed a civil rights case on behalf of Abner against the city. And one of the things that Abner insisted that we do and happened is that we made New York City, as a condition of the settlement, not renegotiate in their collective bargaining agreement what was called as the 48-hour rule, which said that no police officer could be interviewed about what happened in a case until they had an opportunity over a 48-hour period to talk to the police department, the police union representatives. In other words, to get everybody's story together. And we sued the Policemen's Benevolent Association as well as conspirators in that case, and collected $2 million from them. It's not exactly a trivial matter back then, certainly. And so this is the police officer. I am all for police officers having union protection, having lawyers, but one of the things that came out of the Louima case is that you have to make sure that there are independent lawyers available for other, for cops. I mean, I don't know the answer to this question, but under the New York rules, in theory, if, let's say, in the Chauvin case, so the other officers had been saying to him, get off him, and he didn't, they could try to go to another lawyer rather than have the one police union lawyer represent all of them. Maybe that's not the best example, but that is the kind of thing that has to happen. So I don't want to be misunderstood. The Police Officer Bill of Rights, it sounds like something that everybody should have, their rights, but at the same time, there are provisions in there in these union contracts that really are the secrecy rules. Police Officer Bill of Rights, well, that whole map I showed you of the jurisdictions that don't reveal adjudicated acts of misconduct comes out of those rules.
Let's take the next one. And then just to gauge it, are you good for 10 more minutes?
Yeah, I'm good for 10 more minutes.
Okay, all right. Let's go ahead and take the one directly below it. Can you say a little bit more about wrongful convictions due to eyewitness testimony and what is being done nationally to address that issue?
Right. So we litigated a lot of cases because it turned out that there was, decades of really good experimental psychology research in the area of eyewitness identification, so that we knew what the reforms were. When photos or even a corporeal lineup of photos are shown to an eyewitness, first you must say to the witness, I'm going to show you some photos, but the person who actually committed the crime here or attacked you or whatever the incident is may not be in these photos. And if that's the case, don't worry, the investigation will continue. So just doing that, studies show drop in incorrect identifications by 20%, just giving the warning. And then I can go on to describe, other protections. The way that the eyewitness procedure should be conducted is blind or double blind. That is, the person showing the photos or the individuals should not know who the suspect is, because you can inadvertently cue the witness. Not only that, after an identification is made, if you know who the suspect is, you might say, aha, that's right? And give encouragement. And that can create false confidence in the witness. And the studies show that a witness that gets this kind of confirming feedback will all of a sudden believe that they had a better opportunity to view than they did. their certainty will skyrocket, et cetera. So what ought to happen at the time of the first identification procedure is that there should be a statement of confidence taken from the witness at that time in their own words. And the reason why that's so important is that it turns out that unless you take a confidence statement under pristine conditions that way, it can be a false indicator about reliability. But if you get a good confidence statement with a proper set of procedures, it can correlate correctly well with reliability. It's a big issue in this field. And they're using signal detection theory and all kinds of things to start looking at the issue of certainty. But that's very important to avoid confirming feedback. So we have all these protections in what we call sort of state-controlled variables, because the way you do the procedure, the state can control. But then there are other kinds of variables called estimator variables that you really can't control that still can create problems, like weapon focus, cross-racial identifications have traditionally been unreliable. There are reasons for that. So if you want to look at a really good scientifically exhaustive study of what's going on in the field of eyewitness misidentification, read again another report from the National Academy of Science called Identifying the Culprit that lays a lot of this out. One of the things that is going to be one of our major focuses these days in terms of the court system and legislation is that the one thing that a jury should never see, how you watch all the TV shows and movies and they go, do you see that person in the courtroom today? And the witness goes, yes, pointing to the defendant, right? Well, that kind of in-court identification has zero probative value, zero probative value. Who else would you pick out, right? When you're in the courtroom. I'm not saying sometimes that they pick the wrong person, but that is not what juries should be thinking about. It has all this impact. Witness looks highly certain. The most important, by the time you get to trial, the witness's certainty will inevitably grow because they'll hear about other evidence. Why are we having a trial unless law enforcement thought we had the right person? But the key thing to understand is that an eyewitness case, you should bring in the out-of-court identification procedure and get the confidence statement at the time of the identification. Certainty has no probative value unless it's taken at the time of the identification under proper eyewitness conditions. So the in-court identification is the next thing we'd like to change.
Awesome. I'm going to drop down 3 questions to get a different person asking. How do we nationalize a police training program known as TPM, Transformational Policing Model, Bridging the Racial Divide?
Oh, I think I have heard something about that. Well, that is one thing that should be incentivized, having to do with the George Floyd Act. There are lots of different programs of training that can really, I mentioned one, Noble, about training third-party officers to de-escalate situations when one of their own is going off the rails. But obviously, we're all, I think, now in institutions where you have diversity and inclusion committees, and people try to discuss the issue of race among themselves and get some real understandings and ways of working together. And nowhere is that more important than in policing in many ways, because it is a dangerous job. People can get killed. It requires, a certain amount of courage. But of course, I think it has to be reimagined as well. There are so many jobs we expect police to do, having to do with mental health issues or substance abuse issues, or they get called into scenes when, frankly, people carrying guns with not a lot of training in this area are not the right people to be there. So there's controversy about Sometimes people use the term defund the police, probably, politically not the best way to put it, but certainly reimagining it and redesigning it is extremely important. And I'm not completely familiar with TPM, but I just assume that it may well be one of those programs that people ought to be looking at.
Cool. So we have 3 more minutes and 2 questions, which potentially are yes or no. I'll ask the first one and then we'll see if we have time for the second. In June of last year, hackers exposed confidential files of over 200 police departments throughout America, commonly referred to as blue leaks. Has any of this information been used by the Innocence Project?
Boy, I can tell you not to my knowledge. I mean, to the extent that any of those leaks got into the newspapers, we read them like anybody else. But we don't have hackers trying to get into police files. And one of the reasons, by the way, is that we're dealing with old cases, right? The average number of years I think that our clients have been in prison is at least 14 and a half, maybe going up. So, I'm not suggesting that defense lawyers or public defenders are involved in hacking these days, but the Innocence Project and people in the Innocence Network, to my knowledge, don't do that.
All right, let's take up the last one. Any legislative movement you know of to move the DNA forensic labs out of the police and sheriff's departments and to make them independent?
Yes, actually, I think about 3 weeks ago, I was one of the number of people that Sheila Jackson Lee, who was chair of the House Judiciary Committee on what they call the pretrial process. I think the title of the hearing was from Miranda to Gideon, or from Gideon to Miranda, I can't remember which, but the pretrial process. And I specifically addressed that because the model crime lab now in the United States is the Houston Forensic Science Center. And what happened there is that we had an exoneration in Harris County, Houston, Texas, on the Houston Police Department. It involved misconduct in the Houston Police Department crime lab. To his great credit, the police chief there, Harold Hurt, got Michael Bromwich. You may remember Michael Bromwich. He was an inspector general and for Janet Reno, who did an incredible investigation of the materials and trace unit at the FBI before the Oklahoma bombing case, and actually realized that they could not be trusted to testify in that case, and they brought in the British to do it. It was an extraordinary thing when you think about it. And Michael, the Bromwich report was a very big deal in changing the way the FBI did business. Then Michael did this audit of the Houston Police Department crime lab, which was the largest audit, I think, to this day of any crime lab ever, and found that, like in serology, something like, 80, 90% of the cases, there was unreliable methods were used. And so this became a very big deal. We actually were part of our law firm, and another one sued the Houston Police Department, sued the city of Houston over what the crime lab did. And we won. We filed what they call a Manel claim, custom pattern of practice claim. And what eventually happened after that lawsuit, an ultimate settlement of the case, is that Harris County, which is Houston, developed an independent governmental entity, which is completely transparent, that is doing the best forensic science in the United States. You want to know what their protocols are, you go online at the Houston Forensic Science Center and you will see it. They do what is called blind proficiency testing. That is to say, they give samples to the people that are working on fingerprints, ballistics, you name it, DNA, and they don't know they're being tested, right? Double-blind proficiency testing. They have a governing board, just like I was talking about Senate Bill 2 here, oversight body for police. They have a governing board that has civilians, that has interdisciplinary, lots of experts that oversee the crime lab. Sandra Guerra Thompson wrote a great book about this whole period. I think it's called Cops and Lab Coats. I mentioned in my congressional testimony. So, Peter Stout and his colleagues at the Houston Forensic Science Center, that's the place to go. That's how they ought to be designed. They should, because as I started, I think I told you, forensic science, 90% of these, I deliberately did not say crime laboratories, right? Forensic science laboratories are in police departments. Their budgets are governed by police departments. What happened in the Houston Police Department crime lab is that when they didn't have money and they cut funding to the serology unit, the guy that was running it, Bowling, was saying, I rang the alarm and I rang the alarm again, saying, I can't do this work correctly. And sure enough, they didn't. They cut corners. You can't do that. It's like running a hospital and you don't give people proper equipment or backup to perform the procedures correctly. And you can't do that. What a crime lab has to do, or a forensic laboratory has to do, when the funding sources begin to dry up and they cannot do a scientifically responsible job, they just have to say, we can't take any more cases. And that's very hard to do. If you're working in a police department and you're even a sworn officer, they'll order you to take them. And that is improper. And I would say it's one of the major problems with getting reliable forensic science going as it should be in the United States.
Thanks, Barry. It's awesome. Great talk. I want to thank everybody who attended tonight and earlier in the day. I want to thank all of the faculty at BC who got the word out to students and helped us have an amazing attendance. Thank you so much for all the support consistently from all of you. I want to thank the Distinguished Speaker Series once again, including Benny, who's still with us, making sure everything ran smoothly. Thanks to all of you over there. And of course, most of all, I want to thank you, Barry. Really appreciate your time. Your work is incredible. I've been a huge fan of you personally, and it's such an honor to get to bring you to Bakersfield College. So thank you so much for your time. I'd love to meet you in person sometime. Remember, if you're ever on the West Coast, hit me up and I will buy you a Negroni.
And I'll make you the Negroni. Thank you all. This was a lot of fun.
Hey, thanks again.
It's a great program. Thank you.
Keep doing great work. Appreciate you. Take care. Thanks, everybody. Good night.